Juvenile cases. When a juvenile is suspected of violating a crime statute, the procedure that's followed is very different from that used for adult offenders in a typical criminal case. All states have created a special juvenile court system for minors who get into trouble with the law. And although some minors are ultimately judged to be delinquent by these juvenile courts, the different players in a typical juvenile case, including police officers, prosecutors, and judges, have broad discretion to fashion other outcomes. Although the procedure for juvenile delinquency cases varies from state to state, the following is a rundown of a typical juvenile case. How police deal with juveniles? There are numbers of ways that a minor might come into contact with law enforcement over the alleged violation of a criminal statute. Some minors are arrested by police, while others are referred to the police by parents or school officials. Regardless of how the police get wind of a potential juvenile case, a police officer may decide to deal with the juvenile in several ways. Issue a warning. The police officer can detain the minor, issue a warning, and then let the minor go. This is often referred as to the counseled and released alternative. Hold the minor until parent comes. Sometimes the police officer will detain the minor, issue a warning, and then release the minor to the custody of a parent or guardian. Refer to juvenile court. The police officer may also place the juvenile in custody and refer the case to juvenile court. When cases go to juvenile court, once the police officer refers a case to juvenile court, a prosecutor or juvenile court intake officer, often a probation officer, takes over. That person may decide to dismiss the case, handle the matter informally, or file formal charges, called petitioning the case. In deciding how to proceed, the prosecutor or intake officer will typically consider the severity of the offense, the juvenile's age, the juvenile past record, the strength of the evidence in the case, the juvenile genders. Boys are more likely to be charged than girls, the juvenile's social history, and the ability of the minor parents to control his or her behavior. In an average year, about 20% of the cases referred to a juvenile court intake officer are dismissed, and another 25% or so are handled informally. The remaining cases go through formal proceedings. Informal proceedings. If the prosecutor or probation officer decides to proceed with a juvenile's case informally, usually the minor must appear before a probation officer or judge. Although no formal charge is entered against the juvenile, he or she will usually be required to do one or more of the following: listen to a stern lecture, attend counseling, attend after-school classes, repay the victim for damages, pay a fine, perform community service work, or enter probation. If the juvenile's abuse or neglect is suspected as part of the case, The juvenile court judge may initiate proceeding to remove the minor from parental or guardian custody. Formal proceeding. Petitioning the case. If the prosecutor or probation officer decides to proceed formally, he or she will file a petition in juvenile court. The minor is then arraigned, formally charged, in front of a juvenile court or judged referee. In some cases, the court may decide to send the juvenile to adult criminal court.